a lot of people, at least in Arizona, very pro Second Amendment type of a state, look to me as I'm probably the most well-known Second Amendment attorney here in Arizona. And there's the legal analysis of the Second Amendment, and then there's how Live and Let Live would approach the Second Amendment. I don't think they're all that different. In fact, I'm not that worried about the Second Amendment at the moment. Speaking on the legal side for a moment, we just got 3 new justices on the United States Supreme Court. All 3, as I understand and expect, are very pro Second Amendment. So I think the Second Amendment is going to be very safe for quite some time. We had the Heller case in 2008. There's the case out of Hawaii, Young versus Hawaii. And this one squarely addresses the question about whether what we'll call the Heller doctrine should be extended to outside the home. I think it will be extended to outside the home. It's not just a matter of keeping arms, it's a matter of bearing arms. On the Live and Let Live side, I feel exactly the same way as I feel about everything else. Do whatever you want, don't violate the rules. So if you want to have a firearm, as long as you don't violate the rule, you should get to do whatever you want. Obviously, using a gun to commit a crime violates the rules. So all gun crimes should be illegal. But there are other things that a person could do with a firearm, even merely possessing one, that I think could violate the rule. For example, here's an area where I have a slight difference with the current state of the law. The current state of the law says if you have a felony on your record under federal law, you're a prohibited possessor. I think that's too broad. I think if you have a violent felony on your record, now we have reason to believe that you're a substantial risk with a gun, right? Because you've proven to us that you are. You've used a firearm, you've committed a gun crime or something. I think that we can now conclude, based on your past history, that you having a gun is a substantial risk of harm to another person, and therefore you violate the rule by having a gun. And so I think we can tell that person, sorry, you can't have a gun. Now, in fairness, you may have rehabilitation over a period of time, enough time may have passed, and such a person might say, look, I'm no longer a substantial risk with a firearm. Okay, they should be entitled to a hearing with a judge and maybe a psychological evaluation and character witnesses and everything else we have in a hearing. And if a judge finds that, okay, you screwed up 20 years ago, but you know what? You've lived a good life over the last 20 or 10 or 5 or whatever the judge thinks is appropriate, you get your rights back. I think there's a couple other categories too. If you're mentally ill, if you're not competent, this is the same reason we say a 4-year-old can't have a firearm. They're a substantial risk with the gun. So is someone who has mental health issues. So we can tell that person, sorry, you can't have a gun because you're a substantial risk to another person. Third category, there might be some types of weapons that without the proper training, you're a substantial risk, right? Imagine, I often use a belt-fed, tripod mounted automatic 50 caliber machine gun. If you don't know what end the round exits the weapon from, okay, you're probably a substantial risk. You just don't know how to store this thing. You don't know how to use it. I'm not saying that these should be used as a mechanism to deprive people of guns, but there's a happy medium between, sorry, you need some training and nobody should have it, and you could just have anything you want without any training. I think a reasonable course for certain weapons, maybe even all weapons, I think that's a community decision, a reasonable course where we can now say, you know what, this person is not a substantial risk to another person with a firearm, even a dangerous one. Hey, if they're not a substantial risk, they should be left alone. So that's the way I see the Second Amendment and the right to keep and bear arms. It's not an absolute thing. It's not that anybody gets to have anything they want under any circumstances, right? I mean, to dispel that, you could think about the 4-year-old who claims the right to have a gun, a Second Amendment, or the person who's convicted of murder and sent to prison. That person might want to take their AR-15 with them. I think most reasonable people would say, look, sorry, you have forfeit that right to keep and bear arms. Well, if that's the case, this isn't an absolute type of a right. In fact, no right is absolute, right? I mean, you could be put in prison for committing a certain crime. We could take away your very freedom. So every right has its limits. You don't get to intrude on other people. And the gun analysis ought to be no different than the marijuana analysis. It's exactly the same question.